the Washington Redskins, and it wasn't specifically about the Washington Redskins, right? But it was about what you can trademark and what you can't trademark, and I thought that was it was a pretty interesting decision because it actually dealt with the name of a band, and this was part of the CNN story on it. Listen. Hold on. Liz, are we popped up over there? There we go. Here we go.
What's interesting about this case is that this involved a band called the Slants. They wanted to register their trademark, but the trademark office said that the Slants was disparaging to Asian Americans. So they took this through the court system beginning in 2011. And today, the Supreme Court saying that, no, this is part of free speech. The trademark office cannot reject trademark applications on this basis of merely disparaging people.
So, in other words, it opens up a lot of opportunities. I remember the Washington Redskins had a problem a while back, too. Elizabeth Slattery is joining us right now. She's a legal fellow with the Institute for Constitutional Government at the Heritage Foundation. Elizabeth, good afternoon.
Thanks for having me.
Yeah, absolutely. I was personally thrilled with this decision by the Supreme Court. What are the implications for other cases here?
Sure. So, of course, the Supreme Court decided the case dealing with the Asian American dance rock group, the Slants, but it has implications for the Washington Redskins case, which is pending at a lower court based in Richmond, Virginia. So, in 2014, the trademark office canceled the Redskins' trademark of six specific trademarks, which basically means that it was the team would be unable to invoke federal remedies in preventing others from selling merchandise or services that use the term the Washington Redskins. So that's depriving the business of a pretty valuable property right. So that case it has been on hold since the Supreme Court decided to take the Slants case. And so now I think it's likely that the lower court, they would be hard-pressed to rule against the Redskins now because, the patent office had said, well, this term is disparaging to Native Americans, even though the applicable law requires that the court look at how the term was viewed when the trademark was first issued in 1967, not how it's viewed today. Although I would point out that the Washington Post has a poll from last year that says 9 in 10 Native Americans that they polled did not have a problem with the Redskins name.
Yeah, thank you. So my perception of the Redskins case when it happened was that it all came about around the same time that then President Barack Obama said that he was going to ask the Redskins owner to change the name because it offended him. And then suddenly this decision was handed down against the Redskins, depriving them of the ability to use this trademark. Was it viewed by the court or mentioned that it was vindictive in any way? I wonder if they'll decide that.
So the Redskins case did not actually specifically come up in the Supreme Court's ruling this week, and in fact, the group of plaintiffs that had been trying to get the Redskins to lose their trademarks and to change their name. This has been a movement that's been going on since the 1990s, and they had been thrown out of court before, and they brought another action. So, it may be a coincidence that President Obama made those statements, and then the Patent and Trademark Office canceled the trademarks of the Redskins, or it could have been this was a situation that had been brewing for a while, and they felt like they were emboldened by statements of the president.
Interesting. So, are there other implications here? To me, it looks like they were policing speech, is what the court ruled. So when I've seen people sue their state license offices because they want to get a certain vanity plate, and for whatever reason, the state determines that, well, you can't have the word slant on your license plate because it might offend somebody. Would it go that far?
It would not, and actually the court specifically addressed the issue of specialty license plates issued by states. There was actually a case the court heard a couple terms ago where they basically said that that is an instance where it's government speech rather than private speech, even though the message conveyed is something specific to the individual applying for it. But they said the justices have said in certain instances that the speech is so closely identified in the public mind with the government that they will consider it government speech. So specialty license plates are considered government speech. Monuments that are donated to public parks, that's also considered government speech. And another pretty famous case was ads for the sale of beef, to promote the sale of beef, that were paid for by Congress, or authorized by Congress, paid for by the Department of Agriculture. That was also considered government speech.
Huh. Yeah, that's interesting. So maybe, I guess we're going to probably see some action now by the Redskins. I wonder if they could go back retroactively and try to make some of their money back.
Yeah, that's a good question. What happens to anything that they lost out in the intervening time? I mean, the years since their trademarks were canceled in 2014. But I think they'll likely be moving pretty quickly to have the court apply this Supreme Court decision. And of course, Dan Snyder, the owner of the Redskins, has been adamant for years that he is not changing the name.
Wouldn't change it, right? That's true. Elizabeth Slattery, thanks so much for your insight on this. I appreciate it.
Thanks for having me.
Yep, I'll direct people to heritage.org to read more on that story and many other things that they have on there. Yeah, that's interesting. So it's not going to be quite as far-reaching as I thought in this effort to impose political correctness on it. But when this decision was made yesterday, of course, it was picked up by TV and radio hosts and shows across the country. And the left was very angry about this decision. It felt like you should be able to spare people from grief, because of course if you've read the Constitution really well, it's very clear that you have a right to not be offended. I'm kidding. It's silliness is what it is. You're worried that somebody's feelings are going to be hurt. So one of the ESPN former ESPN anchor, a guy named Mike Francesa, who's a talk show host, was talking about this case yesterday, and he repeatedly used a term for the defendants in the case. So the defendants in the case were Asian American or of Oriental descent, which is why they wanted to use this name for their band, the Slants. And somebody at the trademark office felt like you couldn't trademark something that other people perceived to be as racially insensitive. So this Francesa guy comes out, and instead of referring to them as Asian Americans, he referred to them as Oriental Americans, even though the wording in the decision by the court refers to the word Oriental for the origin of the individuals who brought the case. And the left has made hay out of this, and they're blasting the guy for not being aware that the word Oriental was offensive. And they made him go on camera and basically apologize for it. That's where we've gone in this country. You can't. It's the death of common sense that you can't use everyday words anymore. The word police are going to get you if you say those things. We live with it on radio. We do. Liz has got her hand poised over the dump button at all times on my radio show, and she uses it more often than you might think. Is that fair for me to say?
That is absolutely fair.
And I'll say afterwards, did you dump out of that? And she'll say, I did, because I don't want you to get in trouble. So sometimes
I like my job and I like your job.
Sometimes my filter works and sometimes my filter doesn't work. I'm just saying.
It's not just for you.
No, it's for callers too. I would agree with that. But, come on. Here's what I want. I want Miami University in Ohio, my alma mater, to change the name of their mascot back from the weak one they went to, which is Red Hawks, back to the Redskins. I grew up in Ohio. The school was named after the Miami tribe of Indians that lived in that area. To honor them, Miami University. And they had a big warrior chief like they did with the Illini, Chief Illiniwek. Did away with all of that because of political correctness years ago. Now they can bring it back and they can trademark it and make more money off of it. Come on. We'll get a petition. Petition.org. I'm going there now. All right, 314-969-9797. Yesterday, a court put the slam down